I'm going to start over. Yes, Angel Baby, it does have to do with cameras in court. I can see you guys. I don't think anyone can see me yet. Thanks, Roz. Yes, it's the motion for the media blade. I started too early here. Oops. Okay, so I'm live now. I can't tell. This is awful. Hello. Okay, I'm going to start over. Goodness knows what the recording is going to look like. Hi, Angel Baby. Yes. Okay. Great. Thank you for answering me. I'm sitting here talking in my office by myself like a crazy person. Channel 9 has filed a motion to intervene in Boone's case just about the cameras. And they make some good points, and I want to talk about it. I'm going to read you the document. So I'm going to start all over again. WFTV Channel 9 moves to intervene in this action for the limited purpose of opposing closure of judicial proceedings. In support thereof, the WFTV states as follows. WFTV has covered the murder of George Torres and the arrest, investigation, and prosecution of defendant Sarah Boone. Reporters from WFTV attend court proceedings and rely upon state, county, and local public records, as well as judicial records, as part of their news gathering process. This court has set a physical viewing of the evidence for September 3rd, 2024, and is set to consider the media's attendance at the viewing during a hearing on August 14th. Any closure of the physical viewing directly affects the media's and public's right to monitor this important criminal proceeding. As such, WFTV has standing to intervene and oppose any requested closure. And they cite case law, with the Miami Herald. There's probably a lot of case law involving the Miami Herald in these types of actions. But interestingly, the judge cited a Miami Herald case. So the arguments are going to be interesting. And by the way, I should be looking here at the camera at you, but your chat's over here. So if I'm looking over here, that's why, because I'm trying to see what you're saying. Okay. WFTV would like to be heard in this matter and asserts that any requested closure should be denied. Florida has traditionally served as a model for open government and courts. It is well settled in this state that criminal court proceedings are presumptively open to the public. The Florida Supreme Court has stated that a trial is a public event and what transpires in the courtroom is public property. Therefore, when considering a request to close court proceedings, this court should begin its consideration with the assumption that a pretrial hearing be conducted in open court unless those seeking closure carry their burden to demonstrate a strict and inescapable necessity for closure. In order to justify closure, the moving party must meet an exacting standard and show that closure is necessary to prevent a serious and imminent threat to the administration of justice. No alternative other than a change of venue would protect the defendant's right to a fair trial, and closure would be effective in protecting the rights of this accused without being broader than necessary to accomplish this purpose. So let's talk about this for a minute. Strict and inescapable necessity. That's pretty serious. And exacting standard. Now I'm waiting for Sarah Boone to start using the word exacting in some of her letters. Anyway, one of the issues here is whether or not closure is necessary to prevent serious and imminent threat to the administration of justice. So let's argue for a second the other side. Let's argue Sarah's side just for a second. She's been complaining, oh, the jury pool will get tainted. And oh, if everybody's going to see the evidence, it may have an impact on potential jurors. Well, my argument back is that the video of what she did to Mr. Torres is pretty out there. I mean, that's probably the most damning piece of physical evidence that's digital, but that's a pretty damning piece of evidence. So if that hasn't completely tainted a jury pool, I can't see that this will be. I still think that Sarah wants to control the narrative, and she might not be able to deal with having people watch her facial expressions as she comes face to face with this evidence. I'm reading comments. Yes, Sarah didn't want the evidence out on the internet ahead of trial. And she could possibly argue about that, except that video that she took herself is out there. And she repeatedly writes letters. She repeatedly writes letters to the world. She courts media attention. She just doesn't like it when people don't like when people don't say what she wants them to say. Travelin' Teresa, what point did you make? I missed it. Okay, maybe I'll see it again. So I don't think closure is necessary to prevent imminent threat to the administration of justice, and I don't think that it damages the rights of the accused. And then this other no alternative other than a change of venue would protect the defendant's right to a fair trial. Well, let's just say for a second that Sarah argued somewhat successfully about not having the media be there, because remember, the prosecution said they don't care. It doesn't really bother them. Well, they could simply have the camera on her or on other participants and not put the camera on the actual evidence itself. They could agree to do something like that. Kathy says she's starting to wonder if Sarah will be begging for a plea deal. I still don't think so, because she would have to take responsibility. Teresa, it's been dragging on for over 4 years. Let's keep going. First, closure is not necessary to prevent a serious and imminent threat to the administration of justice. Importantly, the fact that the proceeding will involve viewing evidence does not alter this court's Lewis analysis. So even the case law, or the analysis of the case law, doesn't back up what Sarah wants. They're citing the law here, the case law. The need to examine evidence for its admissibility is not one of the prongs set forth in Lewis and is not sufficient to justify closure. Somebody could argue that the examination of the evidence is not for the purpose of admissibility. Okay. I'm just going to read this. Suppressing a defendant's statement that included potentially damaging admissions, but refusing to seal the statement because even where pretrial publicity includes publication of inadmissible evidence or confessions, a defendant can still receive a fair trial. And that's a big deal because the media, when they report on crimes, they're not getting a team of lawyers to go through it for the specific purpose of determining whether or not that evidence is admissible. They just report on it. It's when the jury is examining the evidence, that's when they're not supposed to be relying on anything other than what's admissible at trial. Oh, Sky Troop thought maybe a lawyer wanted to represent her. It says, "Woo." Yeah, I don't see that happening. Next point. And any attendant publicity is not synonymous with prejudice. That's a really good point. Just because there's publicity doesn't mean there's prejudice. Thank you, Kathy. She truly thinks she should be released with an apology. I just can't anymore with her. Yes, yes, a lot of people feel like that. I just can't anymore. Court explained, prominence does not necessarily produce prejudice and juror impartiality. We have reiterated, does not require ignorance. Jurors are not required to be totally ignorant of the facts and issues involved. Scarcely any of those best qualified to serve as jurors will not have formed some impression or opinion as to the merits of the case. Oh, I'd be out as a juror. Every case of public interest is almost, as a matter of necessity, brought to the attention of all the intelligent people in the vicinity, and scarcely anyone can be found among those best fitted for jurors who has not read or heard of it, and who has not some impression or some opinion in respect to its merits. A presumption of prejudice, our decisions indicate, attends only the extreme case. How many times have we looked at a case, just even here on this channel, gone into it having some information from the media, and then how many times have you changed your mind when hearing the actual evidence presented in court? They cite some case law, pretrial publicity, even pervasive adverse publicity does not inevitably lead to an unfair trial. As such, media attention alone is not a sufficient basis for closure. They cite case law, noting even massive pretrial publicity about a case is not enough to show a serious and imminent threat to the administration of justice or to the denial of fair trial rights. And by the way, this is how a motion should be written and presented. Sarah just uses a lot of words and says, I want this, and everything's everybody else's fault and you're evil. They set out their arguments and they're going through them one by one. And I think they have good points. That's not going to be the end of it. Somebody on the other side could come up with something. The judge could come up with something. Robin says, surely lawyers would have lined up to answer her advertisement. Yeah. I think there was a YouTube lawyer, though, that went to go visit her. Yeah. Second, alternatives to closure exist to protect the defendant's fair trial rights. For example, traditional techniques during jury selection can be used to insulate the jury from the consequences of publicity. And in the case Lewis, noting that when considering whether there is an imminent threat to a defendant's fair trial rights, a court should consider whether traditional judicial techniques to insulate the jury from the consequences of such publicity will ameliorate the problem. And another case finding the defendant failed to meet the burden to justify closure of suppression hearing, in part because the court could effectively protect the defendant's right to a fair trial through the jury selection process and insulate an impaneled jury from additional coverage. Just about everybody's heard of this case. Yes, that's right. Although somebody in the comments said they have a relative who lives in Orlando who's never heard of it. And this is the thing. Sarah wants whatever she asks for. And I think she thinks whatever she wants should be given to her exactly how she wants it. And as much as the judge works to try to help her out here, there is a balancing of rights that has to happen. Adjective, adjective, adjective. Hello, Australia. So, they're making a good argument here. There are other things that they can do if there's a specific piece of evidence that the court is worried about the public seeing. Then the court can simply say, you'll not train your cameras on the evidence. They can train their cameras on Sarah, which, by the way, would actually be worse, in my opinion, because I don't think she's prepared for actually facing the evidence. What do you guys think? Do you think she's faced the evidence, or do you think she's so heartless she just doesn't care? Hi, Tanika's 2 cents. Okay. Rather than a hindrance to the administration of justice and Sixth Amendment rights, heightened public attention only increases the need for the appearance of fairness, so essential to public confidence in the system. Publicity is vital to an open and accountable judicial system. As former Supreme Court Chief Justice Berger, I hope I said that right, explained, without publicity, all other checks are insufficient. In comparison of publicity, all other checks are of small account. Oh, they're getting really philosophical. Oh, somebody's not liking my tone? Look, I started out with this whole thing, coming at this with compassion for her, thinking, oh my gosh, how horrible would it be to be playing a game and waking up and finding that? How horrendous. Until I heard the 911 call and she's not actually doing CPR and she cared more about a cigarette and a Dr. Pepper than her dead boyfriend. Oh, and the me, and not a single ounce of remorse, and then the lies. Well, at a certain point, you start to get snarky. So, I'm snarky. I would not be a good juror on this case. I've followed it way too closely. Okay, back to this. Closure of judicial proceedings should be ordered only when there is a serious and imminent threat, and the definitions of those words are important, serious and imminent, to a defendant's right to receive a fair trial. And even then, alternatives must be considered and restrictions must be narrow. In this case, there is no strict and inescapable necessity. 3 keywords: strict, inescapable, and necessity for closure, and this court should deny any such request. Wherefore, WFTV requests that this court allow it to intervene in this matter for the purpose of opposing closure and deny any requested closure of the September 3rd, 2024 proceeding. And That's it. So, what do you guys think of this? Physical evidence is this suitcase, the bat, and possibly two other things. We don't know for sure, right? And she said in the last hearing that she didn't want people watching her photograph the physical evidence. What is she going to be photographing it with? What what's up with that? Does she think they're giving her phone back? She's focusing on what people say to the cops, thinking of telling how wrong they are and just need to listen to her. Casey, your tone is spot on. Well, with my tone, I can't pretend that I don't think what I think. And I my history, a lot of my history is involving protecting victims. And so when I see absolutely zero compassion and I see victim blaming, and I watched that video of what she did to him, and it's horrible. So, no, I don't feel bad for her. I did in the beginning before I understood anything. Yeah, she also knew she taped the killing. She didn't want to see the laptop. Snark is totally appropriate. Yes, I'm not always snarky. Yes, it was a good day. Her answers are what I call the merry-go-round answers, Angel Baby says. Yeah, it's more like, sounds like who wants it sealed, Kelly? It's Sarah who doesn't want the media there. Yeah, it's Sarah who doesn't want the media there, and I don't think there are legal reasons for that. I don't know, Captain Katie, if the Emmys report will do it for her. Maybe the pics. I don't know. I think she's so buried in her own world that she's constructed. I've known people like that who they just wall all that off. Sadistic